My friends, let us consider that acuity is the refined clarity of thought and perception which enables one to discern subtle truths.
Hey everyone, and welcome to this week's episode of the Acuity podcast. We've got some feedback from viewers, and there was some question about whether or not I actually do enjoy my caffeinated beverages. I really do. This time I brought my coffee out so that you guys can see it. As always, Acuity is best savored over an indulgent and stimulating caffeinated drink. So grab your favorite fix, a steaming cup of coffee, a refreshing Diet Coke, a soothing tea, or prepare to get sweaty with a pre-workout, and let's get started. On the agenda this week, we'll be discussing the anatomy of a medical malpractice claim, what goes into it, what's it like, what to expect. And then, as always, I will discuss a specific topic of concern, this week, misdiagnoses of cancer. Today, we're going to dissect the anatomy of a medical malpractice case, breaking it down into its fundamental components: liability, costs, damages, and the steps. Firstly, liability. Liability is the cornerstone of any medical malpractice claim, involving the identification of its four elements. This is important. These four elements must be proven. Number 1, a duty of care. Was a duty of care owed? Number 2, the standard of care was breached. Number 3, the plaintiff suffered a harm, and that harm was caused by the breach of the standard. So, let's go through each of them one at a time. Duty of care. The healthcare provider must have a professional obligation to the patient. This duty exists when there's a doctor-patient relationship. There are many instances when it's obvious, like a family doctor visit, an emergency physician visit, seeing someone in consult, but there are others where an experienced attorney can look for other negligent parties. Learners, hallway consults, who follows up on investigations, who oversees administrative assistance, who drops the ball with referrals or faxes, and there's a lot more. Next is the standard of care. This refers to the level and type of care that a reasonably prudent healthcare provider would have provided under similar circumstances. It's about comparing the actions taken to what should have been done, and this is almost entirely dependent on expert testimony. Another practitioner, ideally practicing similarly, must be able to state that this failed the standard because the judicial system cannot be expected to know that. Third is a harm. Actual injury or damage must have occurred, whether it's physical, emotional, or financial. And finally is causation. Here we must prove that the deviation from the standard of care directly caused the injury. This link isn't always straightforward and requires detailed medical analysis from experts. For example, if a cancer was delayed in diagnosis by 3 months, the question then is, would that have changed the course for the patient or not? If a serious bacterial infection wasn't treated properly for 1 hour or for 4 hours, would that have made any difference? That's to say that the standard of care deviation must be causally linked to the harm or the outcome that the patient experienced. So these are the 4 pillars that have to be proven. It's important to note, each one of these has to be proven on a balance of probabilities. What that means is you must be 51% sure or more that the practitioner or the clinician failed at each of those elements. So 50-50 chance does not pass the test. 40% chance does not pass the test. It has to be on a balance of probabilities. Next, what does it cost investigating and running a file? They can be much higher than most plaintiffs first appreciate. Medical experts are almost always needed to testify on the standards of care and causation. Their fees can be astronomical due to the time and expertise that's required. These physicians could charge $400, $500, $600 an hour. They go through the chart in great detail, and these charts can be quite thick. So you can imagine that their time starts to accrue really quickly, and so do the costs. Next are court fees, filing fees, discovery costs, transcripts, even service for the defendants. All of those start to add up. Litigation time and opportunity costs is another great example. An attorney sinks a lot of time into a case, and that's their job. But a self-represented litigant will lose a lot of time advancing a file if they're missing time devoted to something else. Cases can drag on for years, with attorneys, court time, and administrative work all accruing costs. There is always the possibility of motions, like summary judgment or evidentiary motions. These are legally complex and compound the costs and complexity. Finally, chart requests and analysis. Obtaining and reviewing medical records is both time-consuming and costly, often involving expert analysis to decipher the medical data. Speaking candidly, this is one of the major benefits of my firm, As I am both a medical expert myself and an attorney, the filtering of cases is much easier for me than many other firms. I can digest a medical chart much quicker and much more efficiently than others can, thereby reducing some of those costs. Overall, the cost of running a medical malpractice file can be in the many tens of thousands of dollars. I went to the Ontario Trial Lawyers Association meeting a year ago, and there they were quoting anywhere in the range of $50,000 to $100,000. So just give that some perspective. How much must a claim must be worth in order to justify sinking that much money up front without knowing the certainty that you're going to win? This brings us to the value of a case. This is also a critical decision given the costs and the duration that a file takes. That's what we call the damages. They are the awards meant to compensate the plaintiff for their harm. Damages are broken down into two big categories. Firstly, pain and suffering. This is non-economic damages that cover physical pain, emotional distress, and the loss of enjoyment of life. These are subjective and often where precedent case law is crucial for arguing what's reasonable. In Canada, this is largely homogenized based on case law and specific Supreme Court decisions. These set an upper bounds for what's reasonable, based on when the decision was made and inflation since that time. The second broad category are pecuniary damages. These are tangible losses like medical expenses, lost wages, valuable services, and future earning capacity. Precedent case law helps in establishing benchmarks for these figures, but this often requires very expensive actuarial work to estimate and is often very contentious both at trial or in mediation. If we think about the difference in litigation rates between Canada and the United States, you might think to yourself, the US are so litigious, they're suing everybody. That is true, but they have greater justification. In the United States, both from an actuarial point of view on pecuniary or financial losses, but especially on the loss of pain, suffering, and loss of enjoyment of life, the values are much, much greater. On average, if a claim here could be worth $500,000 before a big legal firm will take it on, in the United States, hitting that benchmark is much easier. So it's much more likely that lawyers will take a case on because they're more likely to get both their pay and make it worthwhile for the client. Given all these factors, what actually happens during a case? There are several steps that are usually taken serially in a row, contributing to the very long time it takes to run a file. It would be great if you could do a lot of these steps simultaneously, but the problem is that each step has to come before the other. First off is the intake. This is where potential clients present their grievances to a lawyer who conducts an initial assessment for the basis for a claim. The lawyer will often then conduct an analysis of viability, delving deeper, reviewing medical records, consulting with experts to see if there's a deviation from the standard of care, and assessing if there's a provable link or causation to the harm. Once an action has begun and the defense team have been served, the plaintiff team assembles an ADD, an affidavit of disclosing documents. This includes all the written records that will be relevant in the case, both for liability and ideally for damages. Once this is complete, which can take quite some time, the case advances to discoveries, or what they say in the US, depositions. This is where verbal evidence is brought under oath by interrogatories from each side. Both sides learned about each other's case, but we are also measuring the credibility of the parties to see how well they would perform in court. Once all the evidence has been brought forward, it's time to prepare for trial. But during this time, we also seek settlement in a period of negotiation or mediation. Before trial, there's often an attempt to settle. Mediation can be a less adversarial way to resolve disputes. It can be intense, but parties that get a resolution are often happier compared to a court order that could go all one way. For example, if you go to court and the claim could be worth $1 million and you get zero, that really hurts. If you go to mediation and you end up getting several $100,000, but you have agreed to that, in general, the evidence suggests that both parties, the defense and the plaintiffs, are happier with that outcome. Finally is the very expensive, potentially long-lasting trial. Trials are much more rigorous and much more complicated than people think. All the evidence is represented, briefs are written, people are under a lot of psychological stress because at the end of that, there isn't a compromise, there is an order. I'm sure you can get a sense that navigating a medical malpractice case is very complex and a costly endeavor. But it matters. It's about ensuring accountability and seeking justice for those who are harmed by medical negligence. To that end, finding good counsel makes a big difference. Moving on to the medical topic today, missed cancers. When patients hear the word cancer at a visit, it's widely recognized that they phase out. It's such an overwhelming diagnosis with huge ramifications to their lives, it's really important that physicians counsel them thoroughly on the next steps and that they have a good team helping them through the process. Let's begin with the pathophysiology of cancers. At its core, cancer involves genetic mutations leading to one of two possibilities. Oncogene activation, that is, factors turn on that start tumors, or tumor suppressor gene inactivation, that is, turning off the defense mechanisms that protect us against developing cancer. Either situation results in uncontrolled cell growth, invasion, and the potential for metastases, or spread. Each type of cancer has very specific genetic hallmarks which dictate its behavior and its treatment. Oftentimes, oncology teams can't even see or begin to plan without knowing the pathology of the cancer itself. I'm going to run through a few big examples of cancers so you get a sense of how each one can play out. First, breast cancer. This often originates in the ductal or lobular tissue of the breast. Early detection is critical, and markers like the HER2 receptors, estrogen receptors, and progesterone receptor status not only help in diagnosis, but also in tailoring treatment. Misdiagnoses can occur under certain classic pitfalls. Firstly, screening mammography is not performed regularly, or the results are misread, especially for those who have dense breast tissue. Screening is one type of way to catch cancers, but the other is through diagnosing from a patient complaint or issue, such as if a palpable mass is felt. If these issues are dismissed as benign without proper investigation like ultrasound, mammography, MRI, or biopsy, those can be tragic cases. Family history, individual risk factors must play a role in increasing a physician's suspicion to go looking for the cancers. So, a good history and physical, as always, are critical for diagnostics. Next, colorectal cancers. This can be a wide range of cancers, but typically develop from polyps, going through stages from dysplasia to adenocarcinoma. Here, the oversight might include neglecting to screen with colonoscopy or fecal occult blood tests in those over 50 or at other ages depending on their family history and risk factors. Another would be in misinterpreting subtle changes in bowel habits, failing to recognize abnormalities in blood work such as anemias, or failing to act on elevated levels of cancerous markers such as the carcinoembryonic antigen or CEA levels. Third would be prostate cancers. Prostate cancers arise from prostatic epithelial cells with PSA or prostate-specific antigen as the primary screening tool. Between that and digital rectal exams, physicians often will screen patients who are at risk based on their age or other factors to determine what is the likelihood of them developing a cancer and catching it. However, issues can arise with screening PSA levels. For example, if intermediate PSA results lead to inaction rather than further imaging like serial testing, MRI, or biopsy, or if changes in PSA levels are not properly followed up on. Of course, physical exam is an important part of diagnosing as well. The digital rectal exam, where the prostate is palpated for lumps and density, can be done poorly or even neglected altogether. Of course, it is not the most comfortable or shameless test. Physicians should not defer these kinds of uncomfortable examinations just for the patient's comfort and wellness at a visit. They are neglecting the overall health of the patient. And so failing to appropriately examine a patient with the right presentation or who's due for screening is a major fail. Finally, a comment on lung cancers. Lung cancers are often linked to smoking. It's characterized by abnormal growth in the lung tissue. Missed opportunities include not ordering or misinterpreting imaging like chest x-rays or low-dose CT scans, particularly in smokers or those with environmental exposure who present with systemic complaints like night sweats, fevers, and unexplained weight loss. But also for more benign complaints like chronic coughs, coughs with the occasional streak of blood. Physicians have to be diligent in looking for the opportunities to investigate properly and thoroughly so that they don't miss a cancer. Unfortunately, cancers don't always present telling you, hey, think of cancer. You've got to be diligent, like a lifeguard, focusing on where the risks are and looking for the evidence to investigate. As you can see, because cancers are different, there are many different ways that they can be caught. However, there are some universal features to the fast and proper diagnosis of cancers. There are no shortcuts to medicine, and as always, a meticulous history and physical examination is paramount. Risk factors must be thoroughly evaluated, such as family history, personal medical history, lifestyle factors like smoking or diet, as well as environmental exposures, like a work history or recreational activities that people enjoy. Systemic symptoms and the chronicity has to be carefully asked about. Night sweats, fevers, these could be attributed to chronic or recurrent infections, or unintended weight loss may be missed altogether. Any complaint for which a patient presents to a clinician should include a deep dive on the duration, progression, and localization of symptoms. Persistent back pain might be dismissed as mechanical, but could indicate a primary cancer in the retroperitoneum, that is, the back of the abdomen, or metastatic disease. Finally, physical exams need to be comprehensive and not just run through the motions. Palpation of masses, lymph node assessment, and looking for signs like jaundice or changes in pallor, which might suggest liver or blood cancers. Knowing when to phone a friend is also a critical component of cancer workups. A lot of the time, cancer workups require specialist referrals, perhaps most urgently for direct visualization of the inside of your guts. A lot of diagnostic imaging is very poor at looking inside the tube of your intestines, and so direct visualization from a scope can be invaluable for esophageal, gastric, or colonic cancers. These are often underutilized because of system issues, but that doesn't do any service to the patient in front of the physician. Just because you think it might take a long time for a referral to get in or for the patient to be seen, and you know that the system is stressed, does not absolve you of the requirement to put in the referral, especially if the patient is presenting with some of those red flag features or high-risk conditions of concern. Finally, follow-up is where many physicians falter. If imaging or blood work suggests something anomalous, even if incidental, it must be pursued. That anomaly might even be within a normal range, but it might be abnormal for the patient given their unique situation. A great example would be anemias. If your hemoglobin levels are low, a normal blood count has a range. So a 10 or 20 point drop might be from within the normal limits to within the normal limits. But the relative difference still needs attention. There's a responsibility to ensure patients understand the need for follow-up too. But patients don't know what they don't know. Physicians have an obligation as experts to stress the urgency and or facilitate in an accommodation for patients who might not be as aware of the risks of what their complaints might lead to. The impact of missing an early cancer diagnosis can be devastating. It not only affects survival rates, but also the quality of life for patients. As we close, remember, advocating for your health includes understanding these nuances. As both a physician and an attorney, my role is not only to heal, but also to ensure that the practice of medicine adheres to the proper standards of care, safeguarding patient outcomes and advancing trust in our medical system. If you have concerns, visit my website at acuitymedicallaw.com, and thanks for tuning in to this week's episode.